Welcome to This Explainer. Today, we're diving straight into a really fascinating study out of New South Wales, Australia, to uncover some of the hidden trade-offs inside the public defender system. We often just assume that the justice system is a perfectly level playing field, right? But what actually happens when we look at the hard data? We are going to unpack an incredible piece of research by Fabio Martignieghi, who uses some seriously advanced machine learning to answer a pretty uncomfortable question. Does being able to afford a private lawyer literally buy you a better outcome in court? Here is our roadmap for today. We're going to cover 1, the promise of equal justice, 2, the measurement problem, 3, the machine learning solution, 4, public versus private lawyers, 5, the plea bargain trade-off, and finally, 6, the price of justice. All right, let's start with section 1, the promise of equal justice. Because before we get into the math, we really need to establish the massive moral stakes of this data. Way back in 1948, the United Nations recognized equality before the law as a fundamental human right. The core idea is incredibly simple. The government is supposed to provide legal advice, assistance, and representation at absolutely no cost for people who just don't have the means to pay for it. But here's where it gets tricky. Does this equality actually exist in practice when you compare the quality of public versus private lawyers? Having a lawyer in the room is one thing, but having truly equal representation is a whole different ballgame. So the crucial point we're tackling is this. If you get a better court outcome simply because you can afford to cut a check for a private lawyer, the entire democratic principle of equal justice is fundamentally broken. If a public defender cannot achieve the exact same statistical outcomes as a private attorney, well, the system has a major gap. And measuring the reality of that gap is exactly what this study is all about. Which brings us to section 2, the measurement problem. Now, you might be thinking, hey, why don't we just compare the win rates of public defenders to private lawyers and call it a day? Well, that introduces the ultimate villain of our data story, selection bias. Think of it kind of like comparing doctors in an inner-city ER to doctors at a high-end luxury wellness clinic. The ER patients are coming in way sicker to begin with. It's the same in the justice system. Public defenders handle cases for individuals dealing with high levels of pre-existing disadvantage. You literally cannot just compare the outcomes directly because the starting lines for these two groups of defendants are completely different. The only people granted legal aid in the first place are those facing severe disadvantages. To really understand how intense this bias is, we have to look at the administrative data from New South Wales. It brilliantly illustrates the divide. When we look at folks who are granted legal aid versus those who are denied and therefore have to go hire private lawyers, the financial profiles are worlds apart. The mean gross income for the public group is around $134 compared to about $280 for the private group. But the real shocker is the net assets. We're talking about an average of roughly $435 for those granted legal aid, completely dwarfed by over $12,000 for those who are denied. Because these groups are inherently just so vastly different, a simple apples-to-apples comparison is basically impossible without bringing in some heavy-hitting statistics. So, how do we fix that? Let's dive into section 3, the machine learning solution. To solve this age-old measurement problem, the researcher brought in a high-tech detective. Since the rules for assigning legal aid aren't a perfectly rigid mechanical formula, human discretion is involved, standard statistical models just kind of fall short. So he used a technique called double machine learning. By utilizing random forests and feeding over 70 different applicant factors into the AI, the algorithm is able to flexibly learn the latent or hidden assignment rules and standards. This essentially allows the model to map out a propensity score, isolating the lawyer's actual impact and slicing right through that pesky selection bias. Now, I want to take a minute to really break down the density mapping of this propensity score because it is the mathematical anchor of the entire study. What we are looking at is the exact overlap between the group that was granted legal aid, represented by the black bars, and the group that was denied, represented by the white bars. In a perfect world where we want an apples-to-apples comparison, we need to find defendants who are essentially identical on paper, but due to the quirks of the system, one got aid and the other was denied. And this graph mathematically proves the machine learning model found those comparable cases. If you look closely at the distribution, right where the propensity score sits between 0 and 0.45 on the x-axis, the black bars and white bars overlap beautifully. They are practically layered on top of each other. This specific zone of overlap is an absolute game changer. It confirms without a shadow of a doubt that we finally have a valid, unbiased sample to analyze. We've successfully leveled the playing field for the data. And through the model's variable importance and partial dependence analysis, a really interesting trend emerged.
It became crystal clear that a defendant's net income is the absolute dominant trigger for being denied legal aid, completely outweighing their physical assets, like home equity. The machine learning model confirmed that as net income rises, the probability of being denied spikes sharply, whereas a bump in assets barely moves the needle at all.
All right, Section 4, public versus private lawyers. Let's get to the big reveal. With the math completely verified and the selection bias neutralized, what is the actual performance gap in court between these statistically matched defendants? Well, the data reveals a massive 8.1 percentage point drop in the probability of a defendant going to jail if they are denied legal aid and pushed into the private market. Let that sink in for a second. Just by having a private lawyer, a mathematically comparable defendant is 8.1 percentage points less likely to see the inside of a prison cell. And to put that 8.1% drop into perspective, the average positive jail sentence in this specific data set is 46.5 months. That is almost 4 entire years. When we anchor that percentage drop to nearly 4 years of time, we realize that avoiding jail is a profoundly, utterly life-changing outcome for these defendants. We are literally talking about years of human freedom hanging in the balance of this single percentage. But this is where we have to employ the yes, but framework to look even closer at the incarceration spells. Yes, private lawyers absolutely decrease the overall unconditional chance of going to jail, as we can see when we look at the broader pool of all incarceration data. But, and this is a massive but, if we filter the data to look at strictly positive incarceration spells, meaning we only look at the people who actually ended up getting a prison sentence, the dynamic completely flips. The data shows that if a private lawyer's client does end up going to jail, their sentence is actually significantly longer on average than the public defender's client. When you isolate those serving time, the median sentence jumps dramatically from 0.74 years in the overall poll all the way up to 2.75 years. It is a stunning reversal when you strictly analyze those who lose their cases. Now, to ensure these findings weren't just some crazy fluke in the algorithm, the researcher rigorously stress-tested the data. He ran extensive checks for unobserved confounders, basically checking what would happen if the AI missed a crucial variable. He benchmarked absolute worst-case scenarios, testing the omitted variable bias bounds, like what would happen if literally all income variables were omitted from the model. And the result? The treatment effect holds up perfectly. The negative effect on incarceration remains incredibly robust, proving that private lawyers genuinely reduce the overall chance of jail, even in the most adversarial, tough data scenarios we can throw at the model. So, this brings us to a major question in Section 5, the plea bargain trade-off. Why exactly do private lawyers keep you out of jail entirely, but public defenders manage to get you a shorter sentence if you do go? Well, it all comes down to strategy, and understanding this completely unlocks the harsh reality of our justice system. Public lawyers have to rely heavily on plea bargaining. It's a highly time-efficient strategy needed to manage their crushing workloads. It might lead to a guilty plea, sure, but it usually secures a much shorter sentence. Private lawyers, on the flip side, are far more likely to run the case. They fight tooth and nail through a trial to avoid any incarceration at all. It is a classic higher-risk, higher-reward approach. And the machine learning model confirms this strategic divide perfectly. When we look at the guilty plea rates, denying legal aid and thereby forcing a defendant to go the private route decreases the chances of them pleading guilty to the highest charge by 4.6 percentage points. The public defender's guilty plea rate sits at 65%, while the private lawyer rate drops down to 60.4%. Private lawyers clearly have the bandwidth to push back harder against those initial charges. But there is another truly fascinating layer here. Public defenders actually leverage free in-house experts like staff psychiatrists to incredibly effectively highlight mitigating factors during sentencing. This brilliantly balances out the scales. It's why they get much more lenient sentences if their client is conditionally incarcerated. Because private lawyers keep more people out of jail entirely, but public defenders get shorter sentences when they do lose, the study actually finds a completely null net effect on the overall unconditional incarceration duration between the two groups. It's an amazing statistical balancing act. Finally, let's wrap up with Section 6, the price of justice. Because we really can't talk about these court outcomes without talking about the money driving them. We absolutely cannot view public defenders as flawed or less capable lawyers. That's not what the data is saying at all. Rather, they are executing an economic survival strategy. Over the last decade, their per capita funding has declined by 3%. There is a significant pay gap. Public lawyers average about 86,700 Australian dollars compared to private lawyers at almost 95,000. Combine that with a strict mandate to provide maximum access to justice on a fixed budget, and public defenders are forced into operating under crushing workloads. It is a forced trade-off between quantity and quality.
Ultimately, the system itself makes a distinct structural choice. It prefers to spread the budget across as many indigent applicants as humanly possible. Broad access is prioritized, but that inherently means there's way less time allocated per case. And when a lawyer has less time per case, an unavoidable, heavy reliance on plea deals becomes the literal only way the system can function without totally collapsing.
Which leaves us with a pretty provocative final thought, built directly on this data. We say equality before the law is a fundamental human right, but are we as a society actually willing to fund it? Because if we don't properly resource our public defenders, the data proves, mathematically, that justice will remain, at least in part, something that can be bought. It's a sobering look at the intersection of law, machine learning, and economics. Thanks so much for joining me on this explainer, and I will catch you on the next one.